Good afternoon, everybody. I'm Jane Fielding, and I'm head of the Employment, Labour and Equalities team here at Gowling WLG in the UK. And I'm delighted to welcome you to this webinar, which unfortunately we had to postpone from mid-year due to Anna and I both having COVID. Happily, that hasn't hit this time, so we're both here ready to go. And the topic for today is managing the complexities of pregnancy and maternity rights. We've had legislation in this area for many decades now, but judging by the frequency of questions that we get on this area, it isn't one that employers really fully feel confident with. And certainly in times of economic difficulty, which we're sadly facing at the moment in the country, these sorts of questions come up more. Poor sort of behaviours and practices can slip in with some employers, and that has a knock-on effect even to employers trying to do the right thing. So we thought it was very timely to have a refresher on the pitfalls of this, what the law actually says, and best practices. So our speaker today is Anna Fletcher, one of the legal directors in our team, and she's very well placed to cover this topic because she's been advising clients on it for many years now and is very expert in it. So she's going to speak for about 35 minutes. We'll have about 10 minutes for questions before we finish at 1:45. If we don't get to your question, we will come back to you afterwards because usually we find we don't have time to do quite all of them. If you want to ask a question, please can you use the Q&A function, which you'll find on the Zoom screen in the middle at the bottom. The chat function's been disabled, so please use Q&A instead. And you can also use that for any technical questions you've got if you have problems. Lucy Strong, who is our tech support today, will do her best to sort you out, but hopefully everything will run smoothly and that won't be needed. At the end of the webinar, we'll be sending around a short questionnaire by email to everybody who's attended for your feedback. It only takes a couple of minutes to fill in, and we'd be really grateful if you could take the time to do that so that we can see what you liked, what you'd like more of, and we can shape future sessions around that. So I will now turn my video and camera off and hand over to Anna.
Thanks, Jane, and welcome everybody to today's webinar. Just starting in terms of a broad overview of what I want to talk about today. I want to talk about why this is important. I also want to just highlight the risk areas, and these are areas that we see come up time and time again. Then look at miscarriage, IVF and surrogacy, other strands that need to be dealt with as sensitively as pregnancy and maternity. And then finally, to wrap up with a horizon scanning what's coming down the tracks. So in terms of why is this important? Well, you'd like to think that actually pregnancy and maternity discrimination wasn't as frequent as it actually is. And unfortunately, the surveys that have been carried out over the years demonstrate that we're not really moving much further forward. So there was a survey carried out by the Equality and Human Rights Commission back in June 2017, and they found that 77% of mothers said they'd been subjected to a negative and possibly discriminatory experience during pregnancy, maternity leave, and even after they returned from maternity leave. So wind forward 5 years, and unfortunately, only this month we saw a study from Culture Shift which reported that more than 1 in 4 expectant mothers felt reluctant to share their pregnancy news due to fear of stigma from their colleagues and also from managers. And in fact, that figure rises to 46% of those who were surveyed where they'd been in employment for less than 6 months when they became pregnant. So I think it's a very sad reflection on why this continues to be an issue and an experience that must be very difficult for people going about what should actually be a fantastic time for people in terms of having their children and building families. So again, why is it important for your businesses to be aware of these risks? Well, pregnancy and maternity discrimination was the 5th most common form of discrimination claim in 2020-2021. And according to the various cases that are reported, these were incidents involving things like sham redundancies, offensive comments to pregnant employees, failure to implement flexible working options, and being overlooked for promotion. So the whole plethora of employment, the employment life cycle. It's also important from a cost perspective. And that's not just in terms of the cost of litigation, but also the wider costs to your business, from recruitment through to retention, from managers having to deal with bad behaviour, as Jane alluded to earlier, having to deal with formal grievances, and really all those costs that can be quite difficult to quantify. And then you have the risk of adverse publicity. We know that the press is very interested in these sorts of cases, and they appear frequently in all the press coverage, and also, of course, widely spread on social media. The other thing, of course, is that tribunal decisions are now published on the government website. So actually, you get to a situation where if your organisation were to be the subject of a search on that website, and you had been unfortunate enough to have had a decision that went against you, then that would be really easy for somebody to have a look at and to read. So just to recap now, moving on to the Equality Act, because that's obviously where all this legislation comes from. So pregnancy and maternity is a protected characteristic in its own right, and it protects women against discrimination. So when is a woman actually protected? Protection applies during what's known as the protected period. No mystery in that, but basically that's the period from the point at which a woman announces that she is pregnant to the end of her additional maternity leave, if she takes the full 52 weeks maternity leave, or to the date when she returns to work after pregnancy, if she comes back before the end of that full maternity leave. And the protected period also applies where there's no right to leave for a period of 2 weeks after the end of the pregnancy. So that will apply in unfortunate circumstances where, for example, somebody has a miscarriage. So looking in more detail at the claims that can be brought, we have a situation where claims can be brought for direct discrimination. Normally those claims are brought under Section 13 of the Equality Act, but there's a specific provision in Section 18 of the Equality Act that disapplies Section 13. And that's because it provides for extra special protection for women in these circumstances where during the protected period the woman experiences what's called unfavourable treatment because of pregnancy, pregnancy-related illness, for exercising or seeking to exercise or having exercised maternity leave rights. So what can amount to unfavourable treatment? Well, it can be unfavourable treatment which is because of pregnancy or illness, can also be unfavourable treatment for being on compulsory maternity leave or exercising those rights to take ordinary or additional maternity leave. And the Equality and Human Rights Commission Code of Practice, which the Employment Tribunal will take into account, gives some examples of what might constitute unfavourable treatment. So those will include failing to consult with a woman who's on maternity leave about changes to her work or about possible redundancy. It can include disciplining a woman for refusing to carry out tasks due to pregnancy-related risks. It can also include depriving a woman of her right to an annual appraisal or PDR because she was on maternity leave, or excluding pregnant women from business trips. So you can imagine there are a huge number of examples of unfavourable treatment. So pregnancy or being on maternity leave doesn't actually have to be the only reason for the unfavourable treatment. This means that a woman's pregnancy or maternity leave only needs to materially influence the employer's conscious or subconscious decision making for the unfavourable treatment to be discriminatory. Also, we have to be very mindful about this not being time limited. So the protection also applies in respect of decisions which were implemented after the protected period has ended, but where the decision was made during the protected period. So that might be, for example, around redundancy, where a decision has been made but not implemented until the woman has come back from maternity leave. And the really interesting and very important factor to remember here is that we're not talking about less favourable treatment. We're talking about unfavourable treatment. And that means that a woman seeking to exercise this right doesn't have to point to a comparator. So that is a very important consideration here. We also know that the protection extends to associative direct sex discrimination. And again, the Equality and Human Rights Commission Code of Practice anticipates that. It talks about that right arising where a worker is treated less favourably because of an association with a pregnant woman or a woman who's recently given birth, and that person may then have a claim for sex discrimination. So in terms of indirect discrimination and harassment, the protected characteristic of pregnancy and maternity discrimination doesn't actually apply in those situations. But that doesn't mean that an employer can get off scot-free in relation to indirect discrimination or harassment complaints. In those situations, there will still be the prospect of a claim based on the ground of sex rather than pregnancy or maternity leave. And don't forget unfair dismissal. The maternity and parental leave regulations make it automatically unfair to dismiss a woman for a reason connected with her pregnancy or the fact that she's given birth or has taken maternity leave. So it's really important when decisions are being made that if you have a situation where you have somebody who is pregnant or somebody who is on maternity leave, that very careful thought is given to any decisions that are made that affect those employees. So moving on to the next slide, I want to look at risk areas. So this may well be what you want your managers to know. And I suspect when you go about advising, some of the things I'm about to say may resonate. So when it comes to recruitment, the job applicant does not have to tell a prospective employer that she's pregnant during the recruitment process. And it's also unlawful to withdraw a job offer on learning about a woman's pregnancy or dismiss her for non-disclosure at interview. And sadly, we do see those being challenged because managers sometimes feel that they've been duped by somebody, but there is no positive obligation to disclose, just like there's no positive obligation to disclose in relation to disability. When it comes to promotion, it's unlawful not to promote an employee who's the best person for the job because she's pregnant or on maternity leave. So we know there's case law about this, and that's the sort of thing that will be reported in the press quite happily. So the same provisions relate to pay rises. So you can't deprive an individual of a pay rise because she is pregnant or because she has been on maternity leave. And again, there was a case reported in the media this year, and it appears on the government website, about a construction firm where a lady who was due to go on maternity leave had asked for a £2,000 pay rise. That was rejected because she was due to go on maternity leave. She brought a claim, the claim succeeded, and she was awarded £9,000. That goes back to the risk area that I was talking about earlier in relation to cost to the business. Then there's the issue of poor performance. Any employee can be subject to performance management, but it becomes particularly difficult where those issues and those conversations arise during the course of a pregnancy. It can sometimes be really difficult to uncouple the impact of a pregnancy on somebody's performance. So you need to be very mindful that if you're taking any action under a disciplinary or capability procedure, if the reason for that is the pregnancy, then there's a significant risk of a claim. And then risk assessments and medical suspensions. As you know, as an employer, there's an obligation to have a general health and safety risk assessment in place for all your employees. But that also includes considering the specific risks that might arise for employees of childbearing age. For example, those who could become pregnant, those who are pregnant, new mothers, and specifically those who have given birth in the last 6 months, or those who are breastfeeding. And failure to implement risk assessments could be sex discrimination. There are specific risks for employees of childbearing age, and in other guidance it talks about work-related stress, things like lifting and carrying heavy objects, and sitting or standing for long periods of time, as well as things like exposure to toxic chemicals and radioactive materials. And the general guidance on the Health and Safety Executive website that covers this was updated in March 2022. So useful source of information if this is an area that is of concern. So once you've carried out your risk assessment, what then? If you identify that there are risks, then obviously you need to think about steps that you need to take. And that could include having to temporarily change the employee's job if there's a more suitable job available for them. And the thing to remember there is that in that situation, the terms of the contract should not change. So for example, pay needs to remain the same. And we had that confirmed quite a long time ago now in a 2000 case that was a claim brought against British Airways. It's an Employment Appeal Tribunal decision, British Airways and more. And in that case, the Employment Appeal Tribunal upheld the tribunal's finding that transferring of pregnant, and they were called air stewardesses at the time, but cabin crew in today's language, to ground duties on the same basic pay involved substantially less favourable terms and conditions, because the employees in that case lost out on flying allowances, which actually were really substantial, about 25% of their overall pay. So this suggests that the overall level of remuneration for alternative work should not be substantially less. So if you have employees where you need to move them temporarily, and they have, for example, variable compensation packages that are linked to specific performance of duties in the original role, you will still need to take steps to ensure that there is no impact on them. So there may also be situations where you're unable to actually move somebody to a role which removes the risk that you've identified. And in that situation, the employee will be entitled to be suspended on full pay unless the risk can be removed or until maternity leave begins. And in that situation, maternity leave will begin automatically from 4 weeks before the baby's due. So sickness at the end of maternity leave, in that particular case, the employee is counted as being back at work. So just as if they'd returned physically to the workplace, but in this situation, unable to do so because of illness. And it may not be pregnancy-related illness, it could be any illness. And in that situation, the advice is that the absence when the individual was on maternity leave should not be counted, because otherwise, to count that period of leave in addition to sickness absence would amount to maternity discrimination. Maternity, I will come back to that later, but in a redundancy situation, don't forget that where you have somebody on maternity leave, when you're looking at redundancy selection criteria, you should not be discriminating against employees who are or who've been pregnant who are on maternity leave. So moving on to maternity pay and benefits, again, a couple of tricky areas with some helpful case law to give us further clarity. So I'm going to look firstly at childcare vouchers, and then I'm going to look at SMP, statutory maternity pay. So when a woman goes on maternity leave, the legislation makes it clear that her terms and conditions of employment continue to apply, but that's with the exception of terms relating to remuneration. So where you have a non-cash benefit like childcare vouchers, what happens to those childcare vouchers? Well, this decision in Peninsula Business Services and Donaldson gives us some helpful guidance. If you provide childcare vouchers as a benefit in addition to salary, then they must continue to be paid during maternity leave. But where the vouchers are being provided by way of salary sacrifice, they should be regarded as part of remuneration, even though they're not a taxable benefit. So as the right to remuneration falls away during maternity leave, an employer would be perfectly entitled not to continue to provide the benefit during maternity leave. So what about statutory maternity pay and settlement agreements? This case of Campus Living Villages gives us again some helpful guidance here. In this particular case, and it was a case that came before the tax tribunal, not the employment tribunal, the case concerned an employee called Mrs. Sexton. She was dismissed by reason of redundancy while she was pregnant. She brought a claim for unfair dismissal and pregnancy discrimination, which was compromised by way of ACOT 3, so in other words, settled through ACAS, rather than under the terms of the settlement agreement. The employer here agreed to pay her £60,000 in full and final settlement of all the claims arising from her contract of employment, a further £20,000 in respect of injury to feelings. HMRC took a look at this, and to start with, they said that the calculation of statutory maternity pay was wrong because she'd been paid a bonus in what's called the relevant period, which is the 8-week period preceding the 14th week before the baby's due, and that bonus should have been taken into account in calculating her average weekly earnings for the purposes of statutory maternity pay. So there was already an issue there in terms of the actual calculation of statutory maternity pay being wrong, but the tax tribunal also found that the Social Security Contribution and Benefits Act provides an absolute right to statutory maternity pay. So any agreement which purports to contract out of that right is void. So it's quite different to the provisions of Section 203 of the Employment Rights Act. So if you are in a situation where you are looking to compromise or settle claims, and you're looking at a settlement agreement or a COT-free, and the individual has an entitlement to statutory maternity pay, really important to make sure that that entitlement is really clearly specified. So what about nursing mothers? Because this is a situation where you'll often be outside the protected period. The case of Macfarlane and EasyJet is a salient lesson in how you should be dealing with flexible requests or flexible working requests in this area. So the claimants were both cabin crew employed by EasyJet, and they wanted to continue breastfeeding when they returned to work. To facilitate that, they asked for limits to be applied to the maximum duty that they were allocated. So they didn't want to work for more than 8 hours at a time, and they asked in the alternative to be transferred to ground duties. EasyJet refused, and that was considered to be in breach of its health and safety obligations. There was a claim brought for indirect sex discrimination, and that claim succeeded on the basis that the shift pattern that was being applied placed women who wanted to breastfeed at a particular disadvantage, and EasyJet were unable to objectively justify that requirement. So be aware of this sort of claim, because although it won't be pregnancy or maternity discrimination because it falls outside the protected period, it could still amount to a claim for sex discrimination. So moving on to the next slide, I wanted to look at the right to return to work and redundancy, and this proves to be very tricky in many circumstances. So we have regulations, the maternity and parental leave regulations that afford women the right to return to work in broad terms after maternity leave, but there's a distinction that's drawn depending on what sort of maternity leave they've taken. So if you have taken ordinary maternity leave, then the right is to return to the job in which you were employed for your absence. If you're returning from additional maternity leave, so anything between 26 and 52 weeks of the maternity leave, the right is to return to your own job, or where that isn't reasonably practicable for a reason other than redundancy, to another job which is both suitable for the employee and appropriate for the employee to do in the circumstances. We don't see that happen very often. Most often, employees do return to the job that they were doing before they went on maternity leave. When you're dealing with a redundancy situation, you have to take great care around the application of Regulation 10, because that provides an obligation to make an employee an offer of suitable alternative employment once she is redundant or at risk of redundancy. So we know that it's automatically unfair for the purposes of the Employment Rights Act to dismiss a woman by reason of redundancy without complying with Regulation 10. So when we look at Regulation 10, what do we have to look at specifically? When does the obligation arise? In the case of Sefton Borough Council and Wainwright, the Employment Appeal Tribunal held that the obligation under Regulation 10 arose once the decision was taken to delete the claimant's job from the council structure. It didn't arise, as the council was contending, following a competitive interview process to decide which of two employees to slot into a new role, because both their positions were redundant. So as the Employment Appeal Tribunal found, the new role was suitable alternative employment, and therefore Ms. Wainwright was entitled to be offered the role, not required to attend a competitive interview to decide who was the best candidate for the post. The other case that helps with the interpretation of Regulation 10 is this case of Simpson and Ensley Insurance. What Regulation 10 says is that the new contract of employment basically has to provide for work to be done, which is a kind which is both suitable in relation to the employee and appropriate for her to do in the circumstances. And its provisions as to the capacity and place in which she is engaged and as to the other terms and conditions of her employment are not substantially less favourable to her. So what does that actually mean in practice? Well, in this particular case, the Employment Appeal Tribunal held that both elements of suitability had to be considered together. So in other words, the suitability of the work and also the suitability of the terms and conditions that were on offer to decide if the role was suitable. And in this particular case, the reason that it wasn't suitable alternative employment was that the terms relating to the location of work, and it was a transfer from, I think, London to Cheltenham, were not considered to be suitable. So moving on to the issue of miscarriage and stillbirth, a very difficult situation for everybody involved to deal with, and a situation where it's really incumbent on employers to be as sensitive as possible to the situation that the employee will find herself in. And this is a really common form of pregnancy loss. It affects 1 in 4 pregnancies, according to Tommy's, the miscarriage awareness charity. So we're talking about the period before 24 weeks of pregnancy. And the reason that that's important is that there is no statutory protection, in the sense there is no statutory right to take any leave at that point. So not to any form of paid leave, obviously not to maternity leave. And it means that the father or parent will also not be entitled to any kind of statutory paternity leave. And of course, neither the mother, the father or partner will qualify for parental bereavement leave. So that means if somebody needs to take time off work, they'll take time as sick if they are unwell, but other than that, it'll be a case of taking your holiday or taking unpaid leave. And that seems a situation that really does need to be reviewed. In New Zealand, for example, they now have a provision that's been in place since 2021, where there is a new bereavement leave that's been introduced to give people time off, paid time off work. And in Scotland, within the Scottish public sector workforce, there is now a right for parents who suffered miscarriage to take 3 days paid leave. But that can't be extended to the Scottish private sector, because that is a matter that has to be devolved to Westminster, and there's no UK government legislation on this. So the SNP has been campaigning for leave or paid leave to be provided as a right, and there was a suggestion by the SNP that the government should really see the loss of a baby being recognised at any stage in pregnancy, and in particular to provide at least 3 days of paid leave in the event of a miscarriage. The government announced in February this year that it had no intention of introducing bereavement leave following a miscarriage. Anybody who's got organisations operating in Northern Ireland, however, be aware that Northern Ireland is proposing to introduce paid statutory miscarriage leave before the 6th of April 2026. So that means, of course, you know, it's up to the employer. The employer can choose to introduce this type of protection, and employers might decide to do that, although according to the CIPD, only around 25% of employees who've experienced pregnancy or baby loss in the last 5 years received any paid compassionate leave from their employer. We do know there are lots of organisations out there that have introduced their own policies. So organisations like ASOS, Channel 4, Monzo, Able and Cole, amongst organisations also including Virgin Media, who've announced last week that they were going to include up to 10 days paid leave for pregnancy loss, as well as up to 12 weeks neonatal leave. Come back to that in a moment. And of course, after 24 weeks, maternity rights kick in, but obviously it's really important for this to be dealt with really sensitively. And I think referring to maternity leave and maternity pay in those circumstances, you might want to be thinking about a different way of explaining that to employees. I'm going to move on now to look at fertility treatment. And again, there's no right to time off for treatment. And the treatment involved in the IVF process it can be really lengthy. There are lots of different steps, lots of medical intervention. the need for plenty of appointments for various checks, various stages of that process. And in some cases, you might have employees not only needing to take time off to attend actual hospital appointments, you might also have situations where people can't be treated locally. So those hospital appointments become more time consuming. And also the medication that's used during the IVF process can have quite dramatic side effects. So situation where an open conversation is likely to be extremely supportive and helpful for an employee. And as it's particularly difficult to predict and it can be emotionally a very difficult time, even more important that employers seek to support their staff. Having said that, the Fertility Matters at Work survey from 2020 suggested that about a third of people who were going through IVF at the point of the survey had considered leaving their jobs, while 70% had had to take time off sick. So it does appear that some flexibility is needed. And again, in the Equality and Human Rights Code of Practice, there is a recommendation that employers treat requests for time off IVF treatment really sympathetically, and that employers have implemented suitable processes and procedures which will allow employees to ask for time off. ACAS also state that most employers should treat IVF appointments just like any other medical appointment or sickness. But of course, there is no legal requirement for that to be implemented. Then there's the question of deemed pregnancy. So an employee undergoing fertility treatment is only protected against pregnancy discrimination once she's deemed to be pregnant. So we look to this case Mayo, which is a case of the European Court of Justice, which determined that a woman undergoing fertility treatment is deemed to be pregnant when her eggs are harvested and fertilized prior to the embryo being transferred into her womb. So we have that guidance, and that was then affirmed by the Employment Appeal Tribunal in a case called Pipkin. Again, turning to the Statutory Code of Practice published by the Equality and Human Rights Commission, you can see there's a lot of good stuff in this Code of Practice. That provides that where a woman is undergoing IVF, she's protected from the point that the embryo is implanted. She's deemed pregnant, and if the implantation fails, then the protected period ends 2 weeks later, and that's in accordance with Section 18 of the Equality Act. So some of the things to watch out for. We know that not all detrimental treatment connected to IVF will be pregnancy and maternity discrimination if the woman isn't deemed to be pregnant. But before the woman is deemed to be pregnant, she will of course be protected under the Equality Act if she's treated less favourably than a male colleague due to her sex. And there's also the potential here for a male colleague to complain of sex discrimination. And that's because of the way in which the Equality Act works. The Equality Act makes it clear that special protection can be afforded to a woman in connection with pregnancy or childbirth, and that's disregarded for the purposes of direct sex discrimination. So a man can't claim that he's been subjected to less favourable treatment because he's not received the same special treatment. But if a woman is given paid time off, for example, for appointments early in the IVF process, when she isn't deemed to be pregnant, then that wouldn't come within the scope of that exception. So it means that a man could potentially claim sex discrimination. In terms of the future for IVF, there's been plenty of political campaigning for protection, but as we speak, nothing introduced despite campaigning for there to be a right to special protection, legal protection from the point at which fertility treatment starts, and an obligation on employers to have workplace fertility policies, although of course it's open to an employer to have those sorts of policies in place. So moving on in relation to surrogacy, you have commissioning mothers or intended mothers who will eventually be the recipient of the baby that's born by the surrogate. They have no protection against pregnancy or maternity discrimination. They're not entitled to maternity leave, and neither of the intended parents will be, the intended parents can take statutory adoption leave and could qualify for shared parental leave, but nothing in relation to maternity leave. The intended parent in a surrogacy arrangement who is intending to apply for a parental order is also entitled to unpaid time off to accompany the surrogate mother to antenatal appointments, and that's 2 antenatal appointments. So surrogate mother can of course take maternity leave. So it's a very complex and sensitive area. Be aware that where you may be asked for advice in relation to a surrogacy, there are differences between UK and international surrogacy. That would need to be taken into consideration. And also there's some scope for some really quite interesting and potentially quite difficult internal management where colleagues are involved. And we have had a situation of advising an employer where the same-sex couple were working together, and they were the intended parents of a child who was being born by the surrogate who was one of their colleagues. So lots of complexity to deal with there. Any future changes? Well, the Law Commission has looked at this. They closed their consultation back in 2019, October 2019. So many years, well, 3 years ago now, and nothing to date, but it's a watch this space point. So moving to my final slide in terms of the horizon scanning, the future. We heard a lot promised in the employment bill following the Taylor review. We're now, several years out from that. So what might we have been expecting and what is now on the stocks? There was some discussion about flexible working being the default position. The government has rowed back on that, but we may well see this being a day one right. In terms of pregnancy, maternity and redundancy, we now have the Protection from Redundancy, Pregnancy and Family Leave Bill, and that was introduced as a private member's bill, and the aim was that it would extend the protection available for redundancy both during and after pregnancy and after periods of maternity, adoption and shared parental leave. So some of that detail has now been set out. We've now got the bill. So it means that currently we have a situation where employees who are at risk of redundancy during maternity or other family leave must be offered suitable alternative employment, which I talked about in the context of the decisions in Wainwright. And then the idea is this will be extended so that right to suitable alternative employment will continue to apply after 6 months, until 6 months after the employee returns from maternity leave. And it will also apply to pregnant employees before they go on maternity leave. So we'll have to watch for more detail, but the expectation is that when this is introduced, we'll be looking at 2023, possibly 2024. And then in terms of neonatal care, again, the government has promised a new right to 12 weeks paid leave and pay for parents whose babies spend time in neonatal care units. And the original consultation closed back in 2019, and we now have the paid neonatal leave bill, which has received government backing. That was announced back in July 2022. Again, another private member's bill. It had its first reading back in June of this year, and the bill's now progressing to the House of Lords. This will allow parents to take up to 12 weeks of paid leave, in addition to other parental leave entitlements such as maternity and paternity leave, to spend more time with their newborn child in circumstances where babies are admitted to hospital up to the age of 28 days and they have a continuous stay in hospital of 7 full days or more. And that leave must be taken before the end of a period of at least 68 weeks, beginning with the child's birth, and it will be a day one right. There are some explanatory notes attached to the bill which are worth looking at if this is an area that you're looking into. If the bill successfully completes its way through Parliament, then it's likely that we'll see this being implemented somewhere around 18 months after the conclusion of the parliamentary stages, which is likely to be early 2023. So probably nothing on the stocks until 2024. So it really is a case of watch this space. There is a lot to deal with, lots coming up, and I'll leave you to ponder some of the more tricky issues and take some questions.
Thanks very much, Anna. Certainly a lot for people to get their heads around, and as you might expect, we've got quite a few questions that have come in. First up is one which I think we've probably both been asked regularly over the years, which is somebody comes in as maternity cover and they turn out to do a better job, or they are preferred, let's put it that way, over the person who's off on maternity leave. And the question is, what are the options in that situation, and what are the risks if the employer decides to keep the cover and not allow the person to come back from maternity leave?
Okay, considerable risk. This is actually, I think, it's one of the examples that is given by the Equality and Human Rights Commission of unfavourable treatment. So even if your maternity cover is better than your employee, you run a significant risk that if there were to be a claim, that claim would succeed, which I know is one of those areas, as Jane said, we advise on, which can cause quite a lot of tension, I think, in terms of encouraging line managers to understand the need to comply with the legislation.
Yeah, I think it's a high risk area, but it does happen, doesn't it? There's another one about the end of maternity leave, if I group those ones together. So someone is on maternity leave, but they're sick, and that sickness continues after the date they were anticipating coming back. What happens in terms of handling that sick period?
I guess expanding on what I was talking about earlier, it's really a case of going back to your sickness absence policy, treating the individual just like you would treat any other sick employee. So that's, your obligations under the policy, but equally the employee's obligations to report and so on. And then going through the usual process of establishing the cause of the illness, but not taking into account the period that's been spent on maternity leave. It will be a situation where that person is outside the protected period, but you need to make sure that the maternity leave absence isn't counted, because otherwise you run the risk of a claim for sex discrimination.
Yeah, okay. And another one about coming back, and again, this is one we get asked quite frequently. If the person has said they're going to come back on a certain date and then they are asked to take a bunch of accrued holiday, can you refuse that? What are the options there for the employer?
Okay, I mean, obviously, if the employee's complied with your holiday policy and given the right amount of notice, then they will have accrued quite a lot of holiday during the course of their maternity leave. It would be difficult, I think, in those circumstances to say no, but for me, I think to establish what they want to do, because we've plenty of situations where people find it very useful to come back on a kind of phased basis by running off their holiday. So I think it's really a question of having a very conversation with the line manager, HR and the employee to make sure that everyone's expectations are being managed.
Yeah. Okay, and then there's one here which is it's an interesting one, and I'll hazard my answer to it, and then you can tell me if you agree or disagree. So if a pregnant woman is temporarily promoted to a higher role and salary that goes with that higher role, and then she goes on maternity leave before that temporary promotion ends, does the employer have to continue to pay the higher salary, and if so, for how long? For the whole of the maternity leave, or just until the planned promotion end date? I think my view of that would be it would be unfavourable treatment of that person if you didn't pay it, but you only have to pay it until when you would have paid it if they had not gone on maternity leave. So only until the end of the planned promotion, not until the end of the mat leave. Is it, you agree with that, Anna?
I would agree with that. And obviously the other thing to look at as well is how you're calculating statutory maternity pay, because it may be that actually statutory maternity pay has been calculated on the old rate, depending on when the temporary promotion was implemented. And again, an individual might challenge you on that, but legally speaking, you only have to go back and look at that relevant period, so the 8 weeks before the 14th week before the child is born. Yeah.
Okay, and one very quick one, because I'm conscious of time. Do fathers and partners have the right to take time off for antenatal appointments?
Yes, they do. It was a relatively, I can say new right, it's been around for quite a while now, but yes, the right to take time off for antenatal appointments, but it is unpaid.
Yeah, okay, so limited value. Okay, so we're just coming up to 1:45, so we're going to call it a day there. We have had some questions we haven't managed to get to, but we will come back to you if that was one of yours. And somebody's asked whether we'll be circulating a recording and a transcript. They will be available on the website once they're ready. Obviously, we have to check through them, but they will be up hopefully in a few days' time. So thank you very much to Anna for taking us through all of that and for picking up those questions. Thank you to you for listening in and asking those questions. As I said, we will be sending around a feedback questionnaire once the webinar is finished, so do please fill that in. Take a couple of minutes to do that. We'd be really very grateful. Otherwise, we will leave you to get on with the rest of your afternoon. Thank you very much. Bye.
Thank you.